Thanks so much for having us also in this conference and for this panel. Welcome everybody, and thank you very much for choosing us to follow in this part of the conference. My name is Mahsa Shabani. I'm Associate Professor in Health Privacy Law and Innovation at University of Amsterdam. I'm also affiliated with University of Gent. So I will just start with a very broad introduction, and then we will move on to our panel and great panelists that we will talk about the role of the existing health data repositories and how they will actually align or maybe even still stay on their premises, even though the EHDS will be taking on many of these governance roles and so on. So to just give you a little bit of an introduction, the EHDS has been very big on our research agenda since the beginning, from the first draft of 2022 till when we saw the final draft and the regulation in 2025. And together with my collaborators and with my great team, we tried to pick up on so many different aspects of the EHDS in view of what we already experienced as a challenge on the previous regulatory frameworks that we had under the GDPR or the existing national regulations. So we looked a lot at the topics like, okay, what is public interest, how we are going to go on with the discussions about, for example, patients control, also discussions about healthcare professionals' responsibilities and duties, and how this will interact with the existing governance mechanisms like the data access committees and so on. And also some of the discussions about, for example, anonymization and more on the technical side of the discussion. More recently, we also, together with my team, we also gathered empirical data from experts. So this has been a study that has been led by Patricia Severa de la Cruz, she's here, and Theodora Lalova-Sping, that we actually collect these also empirical data, and we went through many of the points about how EHDS is going to impact the current practices of data sharing in different member states. So luckily, the results of these studies are also published. So if you're interested, I think at least one of them is open access. The other, if you don't have access to that, please email us, and I'm happy to provide a copy. But it's more like really, in case you are not very familiar with this topic, this is really nice background that can be found there. And also, most recently, we have the studies, empirical studies that's being conducted by Magdalena Koch, that she's also one of our panelists here, and she went also through the discussion, some of the legal discussions about health data sharing, and especially in the context of federated networks, which she will discuss more today also in her contributions to this panel. So also the results, at least the first part of these results, are also published. So I'm also encouraging you to, to have a look at this. So, and then it's today. So I will also introduce our panel and our panelists after I finish this very short introduction. But for you to just know that what to expect from today's panel, we will go through maybe one main questions that we had actually in mind, that, well, how can the EHDS build on what already exists? So basically, while ensuring that how we can achieve trust, efficiency, and legal certainty. So I think that we really want to have a look back as well on the existing research infrastructure, existing governance mechanisms, and see that how EHDS can benefit from those, can learn from the lessons, or can complement that, of course, under this new regime. So we have also some discussion points that's being prepared, but of course we will go through them after some opening remarks from our panelists, and we will also make sure that we'll keep enough time for the audience and for your questions after the contributions of our panelists. This is my final slide. It's a bit of a promotion. We are also organizing another conference in October. It's going to be focused on the topic of governing algorithms for care. It's going to be in Amsterdam in 5 and 6 of October. So at this moment, also the abstracts, the call for abstracts is open, and also the registration. So I hope that if you are interested, you can also check out this conference website, and if you have any questions, I'm also around. You can just talk to me. Great. So I think with that, we can go back to the main slide of the panel. You can do that. Come here. So we have 3 panelists with us today. I will start with our first panelist, Inge Franke. She's from the Belgian Health Data Authority. Yeah, I want her to please start with your first opening remarks about this topic and what you think that we can actually, learn from the existing secondary users, and how do you see that in the framework of your work now in the Belgian Health Data Authority.
Yes, thank you very much for inviting me. And it's a very big question you ask here, huh? and as I promised, and as we discussed, I think it's important to set the scene a little bit on where we are at this point. I think in many member states, the first deadline we have regarding secondary use is appointing our HDAPs by next year, at 2027. They need to be nominated at the European Commission's level. So several member states are still in the process of assigning a health data access body, which kind of brings it a little bit into perspective on where we are now, and which also immediately says that there's still many questions opened to all of us, actually. When you talked about roles and when you talked about the whole governance, I think what we shouldn't forget, and that's also a little bit your question, I think, is indeed a health data access body has a huge job to do, and I think it has a whole list of tasks to do, and we've discussed it also with the colleagues at VUB. Even when there was this publication on, will they manage to do all that work? And I think that goes together with the governance framework. And I think, very honestly, if you look at the whole list of to-dos alone, no, definitely not. I think the workload is so high and there's so much responsibilities. And I think the only way it can work is when member states discuss and look at their country, their governance structure that is there, and how can you kind of fit in that health data access body within existing structures, which means trying to keep as much as possible the strengths where they are. Like, for example, larger institutions that have larger repositories. In Belgium, we have a lot of examples like Cienzano, like at Federal Services, who are actually already used. They have a lot of experience in working with data access application, even, 100 times more than a newly established HDAP. So I think it's up to every member state to see, okay, what do we have in our system and how can we put that together in a framework where the health data access body can fit in the middle, but you can kind of delegate responsibilities, and then you come to the idea of trusted data holders, maybe, of multiple HDAPs. And I think that's an important aspect to consider at this moment. And that's, I think, honestly, a stage where many of the member states are now in. So first, trying to put things together to see how can we efficiently manage that, and how can we reasonably divide the workload a little bit. Of course, a health data access body has its responsibilities. It will need to assess and stamp the access applications, of course, logically. There shouldn't also be a way, there's a reason why it's important that there's a neutral organ established to evaluate them. But if you look at responsibilities like data preparation, in theory, a data holder, when you follow the regulation strictly, a data holder is responsible to make its data available and to provide the metadata. But as such, that's in theory very dry, all they need to do, which means if you don't go a step further, all data pseudonymizing, preparation, minimization needs to be done at HDAP level, and that's not possible. So I think we need to work with expertise around us to make sure that if institutions are ready to do that, why can they not do that? Many institutions have experience in evaluating data access applications already. It is, of course, a huge game changer in the fact that they will not be the one deciding anymore, the final, especially for data access application, but it's only one step in the process. Of course, the final stamping. If you think of trusted data holders, they can provide advice, which is a really important step. I think they can do part of the processing itself, which I think is an important, really important step, because they know their data. They have the feeling with their data. They know how it's managed. They know how it's collected. So I think the only way to make it work is to make sure that you kind of work in this together as a collaborative effort. Of course, I think it's a huge game changer, and it's a change of mind in now at this point. Even these large data holders, large institutions, they take the decision usually themselves whether or not to release the data. In Belgium, we have the Information Security Committee that kind of overlooks and mainly establish rules on how can it be made available in a safe and secure way, but they are not going to oblige data holders to make their data available, of course, and that's a big change. That is a big change that will need to happen, but that will need to be fit in the existing structure of where we are now. So that's why, if I can talk for Belgium, we are in the process now of finally stamping whether there will be a single HDAP surrounded by the large institution as trusted data holders. We have a lot of emphasis on these regional and federal institutions. We have had some discussions a lot with research institutions, universities, which are a bit more challenging, I think. And that's also where you were heading at, I think. How will we consider them? I think that's also a big challenge in the sense that we want to keep their expertise in their European networks as much as possible. I think that's what we should do. It's a strength in research. So therefore, we very much appreciate the idea that needs to be further developed of authorized participant, especially for those research infrastructures. I can only applaud that and hope that we will find a way to make sure that that will work so that these larger, strong networks can keep their existing structures. But of course, there's a big, and that's still a big gap, is what do we do with all other collaborations that are not within an ERIN or an EDIC applied infrastructure? They're all not that far advanced that they can apply to become an authorized participant. So there's a lot of questions for us to come. I think what we should keep in mind, what I think is not completely undermining, but what I think we should keep in the back of our mind as well that if there are existing agreements, I think we should not rush into changing them. There's also no need. The EHDS clearly mentions that in Article 1. So if there's existing data exchange agreements, why would we now rush into changing them? Give it time, see how it works. I would, I think, appreciate if that will not be an escape or a way to avoid the EHDS, but on the other hand, I think it's a good way for research collaborations to keep going at the moment and not to be brusquely stopped or changed or having to change all their way of working. But that's still a question mark on how we will continue doing that without changing them all into ERICs and EDICs, of course. But I hope that was quite a lot already.
Thanks so much. It was, I think I already have like 10 questions on what you already said. Maybe just to clarify for our audience, I'm not sure if everybody's familiar with the difference between the trusted data holders and authorized participants. Maybe can you give some examples as well to the audience that, let's say, use at Leuven, University Hospital, how do you see that as it will turn to like a trusted data holders? Could you give some other examples? I think it can help the audience as well to follow, the differences between those will help the HDAP.
Yeah, that's many questions in the same time. I think it's true, and that's a complexity, I think, with the university hospitals, that they are kind of affiliated to universities, but they're also in hospitals. And let's maybe answer your questions first on the trusted data holders. So trusted data holders are the special case of data holders, the ones that are trusted. The word says it itself. The one that can do a lot of the work that normally needs to be done by the HDAP themselves. They are allowed to. So they are allowed to operate their own SPE. They are allowed to provide their official advice to an HDAP, and they're allowed also to work independently. For example, for very simple data requests, they can handle them themselves. They will just kind of be transferred from the HDAP to a trusted data holder who can kind of respond to that themselves. And that's why I say there's a lot of institutions already doing that. So why change that system and keep the experience where you have the fact that the applications and the requests will always go over an HDAP will make sure that we will still be able to monitor, but yeah, they can work independently. So that's a trusted data holder has a form of independence. Authorized are participants, and that's, yeah, I think very much under development, and it's an important one. That's more meant for European research infrastructures like the ERICs and the EDICs who already have a European network with an own research infrastructure. And then I think of those strong networks, you probably also already know many of them, like BBMRI, like UKIM, that have already, they have an own processing form, they have an own request system. And the difficulty with them, the idea was to kind of put them independently as kind of one, not outside, but kind of the ones who would be able as a European infrastructure. But then the difficulty came, of course, if they are connected, for example, directly into the European catalog, and you consider them as a European entity, a lot of information might get lost at country level, at member state level. Because, for example, if BBMRI, a very strong European network, only puts its metadata at the European catalog, then you get the problem that if a Belgian researcher is looking in the Belgium catalog and he's like, there's no tissue bank in Belgium, where is that data? But it's, of course, a Belgian node of the BBMRI. So that's why it's a bit complicated with these ERICs and the EDICs, and we're trying to find solutions to connect them both at European and national level, so that an individual researcher can still discover at national level and connect to the national nodes, but at least they can also connect at European level, and they can exist within their structure, to make it very simple. So I think that was your first part of the question. I don't know if I have to go too much into detail, but in Belgium, if you give the example of UZ Leuven as a hospital, we are now, for hospital data, working with hospital data networks. So not trusted data holders, not authorized participants, but health data intermediation entities. In the sense that we know that there are very strong hospitals, but hospitals have a huge administrative burden. And I think hospitals, in my opinion, the hospitals as such, and it can be a little bit different for university hospitals, but I think they should be able to do what they are meant for, and that's delivering care, of course, based on research and get the input, but they should not be overburdened now, again, with secondary use. So that's why in Belgium we are now working on the development of hospital data networks who can relieve the administrative pressure from the hospitals in releasing the data, doing all the duties that a regular data holder should do, but they can centralize it in the sense that we can kind of have a better flow in hospital data, and on the same time we release the administrative burden on hospitals. Of course, UZ Leuven, and you're right, is a bit of a special case, and it's met with many hospitals like that they are, research institutions, and in Belgium they are as one entity affiliated with the universities. So, but I think the easiest way is to consider them what hospital data means as data holders, and not overburden them, but just trying even to release the pressure. I think you can discuss the fact, then, do you give them less, how do we say it, authority over their own data? I think we should also be realistic in that sense. I think the EHDS is a regulation, and an HTAP will anyway just monitor what and apply what the EHDS prescribes. So even if they would have a say in the end, they cannot just do it like today we want to release our data and today not, because they will also have to follow the EHDS. So in that sense, I think it's all a bit, we should not state that. But in my opinion, for hospitals, we really need to reduce the administrative burden and not pressure them even more by making them trusted data holders and giving them even more work, because in theory that means more work. Maybe also more independence, but I think that's kind of something that we should establish, and we can establish with health data intermediation entities as well. But that's our approach. We'll have to discover, and I think we're all searching in the process whether that is the good approach. But putting that together in a government framework is important.
Thanks so much. I think probably we'll follow up on some of this also later on. We can move to the second panelist, Magdalena Kokochakuska. She's the lawyer at Timelex law firm, and also a PhD researcher at University of Gent. So you just put so many different hats, Magdalena, when it comes to the secondary use of health data. I let you pick which one you prefer today.
Thank you, Maxa, for the introduction, and I'm very happy to be here in this panel. Indeed, I think of myself as a person who is wearing at least two invisible hats, professionally speaking. So the first one, and the older one, is the one of a legal advisor. I've been working at Timelex as a counsel, but earlier also in a law firm. And as of a few years ago, I started to also explore the pathway of being a legal researcher. But I would say that being a lawyer, like a legal advisor, takes often precedence whenever I think of some legal questions. I tend to think about the practicality of applying legal frameworks. And the first question that pops in my mind when I have a legal question is, which law is applicable? So when we are talking about reuse or use of health data for medical research, right now there are so many different legal frameworks that apply all at the same time. There is no, apart from EHDS, but I'll get to that, there is no dominant legal framework as of yet. So, that is applying right now to the research and has been applying for some years. So we have GDPR that protects the rights of the patients and the data subjects. We have Data Governance Act that tried to put some frameworks around voluntary sharing of data, data altruism organizations, data intermediary services. In that way, the EU had tried to stimulate this voluntary data sharing, which, yeah, frankly, it did not work. It did not pick up as maybe it was expected. And when we talk about health research, we also talk about AI Act, because often, as we've heard in the previous panel, what is going to happen is that there's going to be AI models that are going to be trained on health data. So at the back of our head, we have to keep in mind, well, are the systems in which the data will be made available for training compatible with the demands of AI Act? Because otherwise the developers won't be incentivized to use those mechanisms. When we talk about AI Act, then we start to talk about harmonized regulation, so medical device regulation. So and then there's IP rights, and the list goes on and on. I would say the challenge that we have right now, and yeah, EHDS, it will come in a few years, but right now there are many initiatives that are ongoing. There are many biobanks or registries that are currently either existing or they are building themselves, because the EU policy on making data available, it's not just a legal effort to pass an act on European health data space. It's actually a range of different initiatives that have been going on for years and years, with a lot of money that has been put into that frameworks. So this complexity and the fact that, we have all the existing legal acts and we have the EHDS, it's not making life easy for the current data holders, for the institutions that want to or have to right now share the data. They cannot wait until EHDS will be up and running, which we saw in the first presentation, and you probably are aware anyhow that it's still going to take some years before it's implemented. I think we need to take into account all of this more dense and more fragmented landscape, not only look at the EHDS in isolation, but also look at these initiatives that have been running for years, and they've often developed their own legal frameworks based on what is the binding law, trying to be compliant with GDPR, trying to be compliant with all these other requirements. And this work, I feel strongly that it cannot be just thrown out the window. Really, I applaud, and I was very happy to hear that, this is also a concern for the health data access bodies, how to make this already gained knowledge and also the results from this knowledge, these registries that are rich with data, how to make them operate under health data, European health data space. And that brings me to my other hat. So in the hat of a researcher, I was actually, when I started the EHDS, was not yet certain. It was not clear whether it's going to be passed. So we were trying to find out other ways to make the data shareable. And one of the avenues that was promoted at the time, but I think it's also promoted now, are federated way of sharing data. So making sure that the data stays with the holder, the institution that collected it, but to make that data available for research either by remote querying or federated learning. So ensuring control over that data by the data holder, but untapping the potential of that data at the same time. So I was very interested in that concept because some of the projects that I was working on used that paradigm of federated sharing of data, and they seem to be under the impression that then we don't really have that many problems, legally speaking. And that was a bit of a challenge for me because I saw a lot of problems and I thought, well, that the data is federated doesn't make the whole system automatically GDPR compliant. So in my PhD work, I decided to meet some of the people that are building these federated repositories and ask them about their experiences. Is it just me that I see a lot of problems with this federated network in terms of legal compliance, not meaning problems that it cannot be done, but challenges that need to be overcome. So in the research that also Maxa showed earlier, I was talking to these experts that were building federated repositories, and indeed they shared a lot about what legal challenges they faced, what benefits and challenges they thought about. But to maybe bring the point home, one of the concerns that was raised was how are these federated networks are going to be compliant with the EHDS. So some of the researchers that I spoke with, they were actually very enthusiastic about EHDS, and they were hopeful that this will stimulate sharing of data and maybe change the mindset of a lot of people that the data can be shared in a legally compliant way. So they were hoping that this will bring movement of the data, as one of the respondents said. But others were fearing that the long time before the EHDS is implemented will actually result in a paralysis of the existing models, because they won't know what do they have to do now. Do they have to apply and register their data sets? What happens with the carefully crafted data access models that they have in place? Is that something that is also non-negotiable will it be completely replaced by the EHDS? Some other practical questions, again, going back to my legal hat, how do you even inform data subjects or the patients? You know, you are right now collecting data from them, for example, in prospective studies. What exactly do you need to tell them about what's going to happen in the future? Are you supposed to tell them in a privacy notice, well, your data will also be shared under EHDS in a few years? There are so many questions. I am very hopeful that this panel will, probably we won't answer all these questions, but it will start this discussion and maybe also result in some common approach, some guidelines. We have the Belgian Data Protection Authority. It would be great to know also what other health data authorities are thinking about this. Are they trying to cooperate? Are they trying to find the models like trusted health data holders? Or are they thinking, okay, now it's just us and everything else cannot really work under the EHDS? So thank you again for bringing this topic here, and I look forward to the discussion.
Thanks so much, Magdalena. It was already very nice setting the scene about also the topic of federated networks and how this will also be coexist maybe under the EHDS. Maybe before passing the mic to Rick to continue with actually the representative of those researchers that you talk to them, I just want to maybe just ask you, maybe it's also easier, it just makes it easier also for the follow-up questions from the audience. Did you, in your interview studies, did you felt that there is maybe one point that you felt that this is really, it's important, that you felt as well that this will come as a challenge about how federated networks will function under the EHDS, that from also your own point of view, you felt, yeah, this is the actually one that actually I want to, you know, follow up on that, and I think that this is the major one.
Okay. Can I go with two?
Of course. Yeah.
So the first one is, I think what was really clear for me after these interviews is that not all research, so that there are different ways to do research, and depending on the research question, you might need different tools. Federated network might be the right way to like train an AI model, but if your research is more in the beginning stage, it might not just be possible. So I think there is no one, or that's what I learned talking to these representatives, is that being very strict on saying, yeah, this is the only model that we're going to follow in, and we're only going to make the data available in a federated way. The data will not be visible to the AI developers. They can only query it and do statistical analysis. That doesn't work for all the research, and I think that's one important point. And the second one was concerns about sustainability. And there was concerns that, yeah, with this promotion of the idea of federation, there is a proliferation of the different initiatives that are producing repositories. But these repositories don't really, or they don't know how to develop a sustainable plan for this repository to exist in the future. How to, and that brings also to the question of EHDS, is it, who is going to be responsible for addressing requests to this repository? The Health Data Access Body doesn't host data, right? There needs to be some way of this repository having funding, having manpower to make the data further available beyond just this funded period. And of course, they were trying to find out monetary models and so on. But again, all this effort was a bit blocked by the fact that, well, in few years we'll have EHDS. So why should we try to put so much work into this and try to design something that will not function in a few years?
Perfect. Thanks so much. So with that, we can move to the last but not least, Rick van Noland. He's from the literature. He's also sitting here to give us first-hand experience of the people that they are actually have existing experiences with health data repositories, and now we really want to hear from you how you are looking at EHDS. Is it going to be challenging? Is it going to be promising? Or is it a mixture of two? Yeah, in general, I think it would be really nice to hear from those that are really involved in managing these health data repositories.
Thanks, and thanks for having me. So indeed, so I'm Rick van Nuland. I'm a program manager at Ligature. We manage large research collaborations, typically in the European space, many of them which have a public-private component. And many of these collaborations, they collect, either they have the primary aim to set up a repository to do research on, or they collect research for a specific purpose. And I think for all of these projects, the European health data space provides a very unique opportunity, right? Because in the end, if it's done well, the European health data space could make these repositories almost obsolete. Because then we don't need to set up individual repositories for a specific disease or to answer a specific research question. However, when we think about the funding landscape, so how these things are funded, it's always with temporary funding. So people really start, when a grant is, or when funding is granted, typically people spend 2-3 years setting up their governance and their technical infrastructure to make data sharing possible between the consortium partners alone, right? So people put in a lot of effort to make that possible. So what will happen and what I see happen is very much what Magdalena already explained, is that people don't really know where we're heading. So they don't act because they're not aware of what is happening, what is going on, and what they need to do. And I think the fact that for some cases there's exceptions made, right, for ERICs and for EDICs, so there are specific instruments, or let's say legal frameworks in place to make that possible. But those are just the tip of the iceberg. I think there's many more research collaborations that have very valuable data where the EHDS applies, where there's no support. So they're run by researchers that need support in preparing for this European health data space, both at the level as to, okay, how do I transform my governance framework to the European health data space framework, but also how to make this practical, right? If I have a repository with data sets coming from different countries, some which are in Europe, some maybe they're not in Europe, some come from companies, some come from research institutes or hospitals. Who has to deposit the metadata to a metadata catalog? Who's responsible? At this point, I think that even those very practical things are still very much unknown, and I think it's very important to take researchers and leaders of large research collaborations by the hand to support them in this process. And I think I very much like your comment, Inge, that we shouldn't rush it, because that makes that people get anxiety and stop moving at all. So I think it's really important that we take research by the hand, we pilot it, not just with the ERICs and the EDICs, but also with other large research collaborations, either in a specific disease area or in a specific data type area. It doesn't matter, but we need to start working with that. And I hope that after March 27, when, following the comment that was made this morning, from there on we will hopefully move towards implementation, but I think that should be rather evolution than revolution. I think we should really start working together, but have clear guidance and support for those infrastructures. And I think there, my observation is that there's a lot of emphasis on the HDAPs and the national implementations, which is very important. But typically, many of the research collaborations funded under EU funding schemes, they don't have, they don't deal with the national HDAP, or at least they think they don't have to deal with the national HDAP. So I think also for those type of collaborations that are, I think, quite typical, but are funded with EU funding, we should really make sure we support them well in this process. Yeah, and I think also one aspect that I want to touch upon is that the data that is collected typically in these repositories is of different nature, and many data is retrospective data. So they're collected under certain consent, under a certain legal basis, and it's still, to me, very much unclear how we should handle that. I think for future data collections, let's say prospective data collections, it's more easy. There we can change and we can do it according to the European health data space. But for these retrospective collections, which are, I think, very valuable, it's very, very unclear for me. And the last thing I also want to mention is the public-private component. So I think in the first panel there was a comment made about, okay, can we create an opt-out for having my data used by private entities, which I think, if you look at what is the European health data space supposed to do, it's supposed to stimulate innovation in Europe, right? To be competitive as Europe, to make sure that we come to better treatments for patients. And I think we should think very carefully about, okay, how do we make this possible, and how do we prevent data from being there but not accessible for the parties that actually are building the innovations. So I would also like to highlight that aspect.
Thanks so much. I think you raised so many important issues, including maybe the lack of support that at this moment that you are feeling, especially for the smaller repositories, that they may not be really in a level that to be recognized maybe as trusted data holders, or maybe different, let's say, entities that is being recognized under the EHDS. But still, they are important players in terms of the data that they have. So maybe we can go back to Inge as well to see that if you have any comments on that. But before, maybe I just want to pick up on your last point about the commercial partnership. And I think this is a question that comes back a lot in so many of the discussions that we have, and some historic mistrust that exists, on citizens about like such data access, by commercial partners and so on. So I wonder if you think like maybe part of it is legitimate because they want to see that the final, let's say, benefit of this research should come back to the society, if there is a commercial involvement. I see you're nodding. If yes, then how do you see that actually we can ensure that, that to allow commercial access, but at the same time to have some, strategy or some policy to make sure that, we can go back and tell to the citizens that, see, this benefits or profits or whatever, it just came back to the society.
Yeah, I think it's a very good point, and I don't have a very clear answer, but there need to be this sort of reciprocity, difficult word, sorry, right? So first to the parties that put in a lot of effort in collecting data sets, because I think we should also acknowledge that, but also to the citizens and to society who in the end paid either through funding or they offered or donated their data to a data holder. I think what is very important that we somehow build in a way to make this transparent, to make very clear what the data is being used for, also if it's used by a commercial entity, and I think the challenge I see is that it's not black and white, right? So if I'm a researcher, an AI researcher, and I want to use digital pathology data from a hospital, and I create a great tool that I, in the end, want to put in a spin-off, right? And I want to somehow create a business out of it. How does this? I still cannot really see how this fits with the idea that we cannot give data to commercial entities, right? Because there's so much of a gray zone there that we need to provide more clarity on, I think. And like the speaker from the patient representative patient forum in the Netherlands, I think said, yeah. I think it's important that we create trust, and I think creating trust we can only do by being transparent about what is being done with the data and building the right measures to ensure that there's no misuse of data.
Thanks. So maybe we just go back again to Health Data Agency and Authority and see that if any of the topics that's been mentioned here resonates as well with you and the work that you have done so far, that maybe you think that, this needs to be picked up by authorities like you to maybe provide more support or maybe provide more legal certainty, or which one do you think that actually it's, you also experience it in the other side of the, let's say, story as a regulator?
Yeah, I think many things are to be said on that. Huh? I think it will, for a health data access body, it will anyway be a balancing act between protecting patients' rights, protecting privacy, but also not limiting innovation and research. I think it's kind of always back and forth and see, and that will be a challenging task for a health data access body. And I think from that sense, I think the EHDS does put a right framework in the sense that if data is available and it fits within the purposes of use, it should be shared unless it's still under IP protection or whatever, or unless there are concerns. So I think it's how would I say, it's the same for all parties. It's the same for the research, it's the same for the private sector. And in that sense, I think it's a beneficial framework for all partners to be put at an equal access level. So in that sense, I think it's a major step forward. Yeah, when you're talking about opt-out, and as we were talking about opt-out in categories, I think we should also make sure that at least continued research, even with a high number of opt-outs, research can continue. And of course, the private sector has a huge impactful research as well, so it should be brought forward, definitely. But it will always be a balancing act. On the other hand, what I think and then we come back on the word trust, I think it's also a huge task for health data access bodies and other authorities to build that trust in citizens, to say, okay, data will be made much more easily available for research, for policy making, for innovation, but we will do that within the right framework. It's not just going to be free traffic of data. There are really concerns that we take into account. It's just not like that. Your data will not just float everywhere. There are regulations. There are health data access bodies and data protection bodies that will make sure that this will happen in a safe and secure way, that's kind of, okay, data will be made available, but with protection measures that are very important there. So again, this balance and not, I think that message is also very, very important to bring along.
May I comment? So I think the point that you started off with by saying, okay, data should be made available, I think it's very important and it's high value, but that's the stick, right? But from a researcher's perspective, where's the carrot? And I think that should be made more clear, and I think we should really think about the right incentives for researchers that have a cohort that they built over many, many years. And I think just providing the stick, I think it's not sufficient to get them on board.
But maybe somewhere, somehow, it's more philosophical. Huh? The carrot is there, that it's not only the obligation is there, but you have the access as well. I mean, it's not only you who will have to make it available, but also other researchers will have to make their data available for you, which might also be beneficial for you and provide more efficiency. I mean, there's so many feasibility studies that are being done similarly, so why not? I mean, maybe the carrot is there, just the fact that, okay, you have to make your data available, but the other parties as well. So you might as well benefit from previous research, from databases, existing databases, or feasibility studies and whatever. So, and of course, there's the fee systems, which, yeah, I mean, are only cost covering, but I would see, I mean, that's a whole concept somewhere, somehow, of data solidarity, I think, which is a theoretical concept, but it is true, and that's the idea, what I say. I think the the fact that EHDS puts, as I was saying, puts everybody on the same level. You know, if you have a good purpose of use and you have good objectives and you have a good way of processing your data, it doesn't matter whether you are a public, well, for some aspects it matters, but I mean, within certain limitations, it doesn't matter whether you are a private sector. If your research fits a good purpose, the fact that you are private or public sector should not influence the fact whether you will be granted access, if your purpose is there, of course. Huh? So in that sense, that I think is beneficial, and the obligations are very much put forward, and everybody thinks we will be obliged to make our data available, but you will also have more access to data, and that's something that
I think for the large part, I can totally agree with that, but I think there's also many situations where I think the cost and the benefit, they don't fall back in the same place, right? When I'm an innovator, I have a small company and I need data, right? I'm not the one providing data. I'm just taking data, right? And the same thing holds true for maybe non-research hospitals. They are basically becoming solely a data provider, and they're not a user. So I think we should really think carefully about the different uses patterns that are there, and what are the different incentives for those patterns.
Yeah, yeah. But yeah, what you said about the hospitals and only being a data provider, yes, indeed. But that's why I've said that I think, in my opinion, it's important that we do, because in my opinion, they are a very special category in the sense that they should do what they are supposed to do, care. And there's already a lot of pressure in primary care. And if that's being in registration, and if that's okay, and we make sure that's a good framework for making the data available, if the basis is there, it shouldn't be too much effort. And that's, yeah, just a bit the counterpart of having a data-driven society, and especially in care, of that data not being lost, and organizing it better is just the foundation there.
No, and
I would think.
I'm all supportive of organizing it better, but the reality, and I think we should be realistic here, is that if I'm a researcher and I need data from different hospitals, just making sure that all this data is curated, right, and is interoperable, it takes a lot of effort. To get it out of the systems, to get it into a data set, and then to transfer it to an SPE. I think it takes a lot of manpower, a lot of also insight into the data. You have to really understand the context of the data. So I think we shouldn't underestimate that part.
No, sure, definitely. That's why I mentioned in the beginning that in Belgium we're really putting, and we're already working very intensively on that, on how to do that without putting too much pressure on the hospitals themselves. Primary care is another thing. I think the basic registration is something that we cannot completely take out of the hospitals. It's something that the primary care registration, primary standardization, semantic operability is something that they should do themselves. But I think if you have that basis layer ready, and then you make sure that you have good common administrative service to kind of extract the data, it's a modality. And as I said, we shouldn't, I mean, there will be more pressure, but it's also up to us as institutions and as member states to be aware of that and to try to find solutions in not overburning them too much, but still it's also I think it's also our task to work towards a data-driven society so that all that data that is there in these electronic health records is not lost. It can be used for data-driven research at all levels, at private sector, at policy level even. So, but I mean, I do agree with you as well, huh? And that's why I mentioned our health data intermediation entities for the hospitals, because we are very much aware of that. But it's not only for them, but of course. But thanks.
so much. So I want to ask another question to Magdalena. So you mentioned in your previous answer that, well, trust is very important. And I wonder, one of the key points under the federated networks is that, well, data stays with the data holders, so this way you can maybe also have higher trust, especially because, yeah, if the data subjects, if they understand that the data doesn't move, I mean, I know that there are a lot of nuances to that, but now let's say under the EHDS, if we bring the governance to a more like centralized way, do you think that it can have some impact as well in how trust has been also perceived under the federated networks? Do you think that it will not, it will clash with what it's being foreseen there?
Yeah, I think that's a very, very important question, because I feel that the promise, the data doesn't move, is a very far-going promise already in like a closed consortium of defined partners, because in practice, and that's what I learned working with those federated networks, is that there might need to be a movement of like a sample of data to make sure that all the nodes have the same data structure, or that the infrastructure is not ready, so maybe we'll do we'll process the data in a different node. Just life brings about complications. So this promise of the data doesn't move is problematic at best. What I've also seen is that, this is also something that is presented, for example, to the ethics committees of the data holders. So for the hospital to be even able to contribute data under the current legal framework, they have to often go through an ethics approval. And then if you're in that application state, well, the data will not move from our infrastructure. It will stay in our node and only will be queried, and you get an approval for that. When the circumstances change, then you face the reality of either going against that approval or trying to explain again what will happen, and getting reapproved for a new purpose. And that's often tied with like the consent that is sought from the patients to take part in a study. Because in a consent, you should be able to explain everything that will happen with your data. And that is already problematic, I would say, and difficult for patients to accept that, for example, there will be a consortium and that your data will not, and sometimes it's very sensitive data like on mental diseases, that it will not only stay within your hospital and sort of the researchers that you sort of know and trust, but that you need to actually share with a group of other researchers. And then to put on top of that, I'm just, again, putting on my lawyer hat, another clause saying that, well, also please note that if there is going to be access through EHDS, then your data actually will move, because it will have to move into a secure processing environment. So I do see a tension of that trust, that, well, first you build the trust with the data holders and try to get them on board with the idea of sharing the data, negotiate the principles, try to make it compliant with GDPR, and then, suddenly there is a change of tone, and you have to account for different circumstances. That's why I'm thinking about this already, right? We have still years to come before the EHDS is operational, but these projects take years. The obtaining consent, especially for studies that are longitudinal, I'm not sure if I'm pronouncing that right, but that take place over years and years. They also take place, it just takes time. So, okay, I am thinking of that because I'm a lawyer and I'm specializing in this domain, but are yeah, is there this knowledge that is spread through all the hospitals or all the researchers that are right now applying for different grants? I'm not so sure. That's why I very much echo what Rick was saying, that there should be, I feel, more support and more noise about EHDS in the media, in the research community, and not to scare people like it's another GDPR that you'll have to do a lot of forms and everyone will be just troubled by it, but to really emphasize the benefits and, as you say, the way that this data can actually benefit European society.
Yeah, just, I mean, just maybe a different thought. We are discussing very much about SPEs, huh? And if I discuss with our technicians, I don't have a technical background, huh? But when I talk with my technicians, they explain me that the highest level of SP federation is that you can do kind of a remote analysis combining data without having access. So that's the highest level. So you combine data. And then when I talk and hear about information security, for them, for a data user, evaluating whether to grant access from the Information Security Committee, and as we will most probably also look at, is that for us, granting access, the fact that the data is moved or not will not be the influential factor, but the completeness of data that the user has access to. Even if it's in a federated, the data is not moving, but if the data is kind of brought in a federated approach together, that access as such to the data set that is combined there, that is crucial in actually granting access or not, because that is kind of your risk of identification. I mean, the fact that the data is transferred is an addition. It's a higher security level, and the fact that the less data is transferred, the less there's a breach. But there's also always a risk when you start combining data of identification. From an information security perspective, I would say that it doesn't really matter whether it's kind of in a federated approach or it's kind of the actual combined data set that you evaluate, whether it's coming there, you have access in a federated approach or not. It's just also maybe, yeah.
So if I understand your point is that, yeah, there might be security risks, whether the data is moved or whether the data is federated, and that, with changing approach, it doesn't mean that this risk level from the security perspective will change. But there is, I'm just thinking about like the literal promise that was made, for example, to the ethics committee, that the data will not move from your infrastructure, right? Mm-hmm. And that promise made to the patients that only these few organizations will have access to that data. Can we keep those promises, or do we say, well, yeah, that promise was made, but under a lot of small print caveats? So, yeah.
Yeah, and I mean, I can totally support that, because what I typically see is that when ethical approval is requested to share a data set or to bring it to a repository, whether it's central or decentralized, typically the request to the ethics committee is as restrictive as possible, right? Because I think we're always, everybody's, maybe for good reasons, very risk averse. So typically the approval is for implementation of the action, which means basically, if you look at it very strictly, you can only use it for that specific project, and then you have to remove it again, right? And I think we have to somehow change that way of thinking, and also maybe the way ethical committees look at it, because that is definitely not promoting innovation, and is really goes against what the EHDS is trying to achieve.
So I think we'll go a bit more on the retrospective use of data that's been already collected, and probably going a little bit on the direction of the legal basis that the EHDS will use to make these existing data available for secondary users. I'm not sure if this is the direction that EHDS should take. I mean, the discussion about the existing data repositories and under which conditions they have been collected, you know, if they actually collected under a specific condition of, for example, being used for a specific project, and now how they can be also accessible under the EHDS.
Well, just going back maybe a little bit, I do know, I mean, in the past, I do agree with the fact that many data repositories have been collected and have been made in agreements, and there's no, in some of the agreements, they included in the consortium agreement or whatever for the specific project, they did include a governance of the database, which should. And in that sense, I think the EHDS might even promote to increase that, because I think somewhere, somehow, you can also consider the fact that that is not governed always as appropriate as it should be. It might also, yeah, bring that a step forward. Now they are maybe obliged to have a bit of a better governance structure. Aside of that, yeah, I can't give an answer to that, but I think another discussion should be, according to the definition of a data holder, are kind of these consortium, can they be considered as an individual data holder or not? In my opinion, that's more personal, they should, because I think it's an important data and it would be a loss. But on the other, from a purely legal perspective, they are most probably not. But I think by forcing them and by also thinking of that improved governance structure in the future, when they make that agreements, that might even help, and it's even a lack, maybe, that now will be improved, I hope, maybe.
Yeah. Thanks. I think it's also, we have a limited time till the end of panel. Maybe we can open it to the audience if there is any question. Yeah, immediately I see here. Is there a mic there? Yeah.
Hello, my name is Simone Morse. I represent the Guild of European Research Intensive Universities, among others Ghent University is a member, so nice to see you on stage. I actually would like to echo what was said by Inge earlier in terms of that it's not just about having others accessing your data, but also that you have access as a researcher to data. I think that's one of the aspects that we discussed a lot during our discussions internally. And maybe also something that we've discussed, and I would like to hear your thoughts on this, on what we need to also further monitor is to determine whether the framework maybe unintentionally influence researchers' behavior in also publishing information. So, for example, the data sharing strategies might be impacted by the way that research is conducted. So, for example, if you have a research cohort and you have to provide data after the first publication, then would that mean that you potentially would not immediately publish the information because you don't want to share the data? Again, these are very hypothetical questions, but these are things that came up during our discussions. And also, what we need to monitor potential changes to the willingness to initiate investigator-driven cohorts, as well as the shift in number of participants in research cohorts, because then you have to now go back to the consent form and say, now, oh, by the way, now you have to follow the EHDS requirements. So how do we engage on this? And so it's also, because if you say in the consent form, your data will not be shared with commercial actors, now, of course, and I agree with you, it doesn't matter in the end if it's a private actor or a public actor, as long as the legitimate reason is there. So these are really big things that we are concerning ourselves with at our network, and I really would like to hear your thoughts on this if you also came across these things. Thank you.
Thanks.
Yeah, I just wanted to say that what you considered a hypothetical situation where people are not willing to share, I don't think it's very hypothetical, right? I think it's real, and I think we all have to be very realistic about this. And And I think also there's I think a big role for the institutions to take their investigators along in this journey and provide them with the support internally. And I know they have a lot of things to do, and they're already struggling with their primary purpose, but yeah, we have to, otherwise we'll fail.
Maybe start from here. Yeah, here. Who was the question? Sorry. Okay. So maybe you can go here. No worries.
I have a very short and practical question. Roxana Albu from Cianzano. For the registries that were built with consent, now that is allowed under European Data Protection Board guideline to use scientific research and legitimate interest as legal basis, what will happen with the consent of those patients? This is one. And second, what is actually the value of the data that were built with public funding money when they will be used by commercial entities to create, let's say, public goods? So how that public good will actually be put in practice? Because these registries were built based on the trust that population gave to such infrastructures. Thank you.
Yeah, not an easy one, and I think we're still searching on that. I do think that we'll have to go through some sort of a transition phase, I think, I'm just thinking out loud that maybe for future informed consent forms for registries, it can kind of be specified that the EHDS will apply, so that at least patients will be informed about the fact that there's something like sharing data afterwards, and that's the whole idea of the EHDS. But of course, I agree, we need to have a look into what do we do with the current informed consents and how do we approach the new ones upcoming. And I think at least the least we should do there is include at least a notification that the EHDS will apply for reuse of data. But it's very, again, I also don't have a legal background, so that's a lot of work to be done by our legal advisors to set the clear framework for that. Then I think registries are always a little bit, a specific category, because we do realize a lot of effort has been done in collecting the data, cleaning the data, validating the data. A lot of data curation has been done. And that's something we should respect, and very often it is indeed done with government funding. And I have to say that I was kind of involved in the TEDAS guidelines on fees, where we specifically try to address that and try to, if you see that very complicated formula where you nearly run away from when you see it, but it does make sense. You know, for registries, we do attempt to suggest to make kind of an exception in the fact that we don't, I mean, that's the basis of registries, is to make sure that secondary use or multiple studies are possible with that data. I mean, okay, primary monitoring and whatever is also possible, but reuse is one of the reasons why you do that. So that's why in the guidelines on fees, we try to include that. We'll see how that will be taken into consideration in comitology, because I do think it's quite an important remark you that, because I mean, public funding, okay, and I think it's also our responsibility, maybe as governments, to make sure that that is, but some of the registries are privately funded or by whatever, you know. I've set up, I was a researcher and I've set up several registries, and it takes a lot of effort to find funding to set it up. So at least the things, that's why we try to do in the fee system. Let's see how that will be consistent, but it is something that we are very aware of, and let's see how that will, be brought forward.
Thanks.
I wanted to shortly comment to the question on consent and also on the previous question, because I think something that is a fundamental question is who is the data holder, and it's so we have this definition. It's very wide, but and I don't know it by heart, but I think it emphasizes that in case of personal data, it should be the controller who has the ability to make the data available. So is it possible to make a legal argument that if you are a controller of a data set and you only have consent to use that data for one specific purpose, then you're not a data holder because you cannot contribute that data to the EHDS? I mean, I can see that legal argument being made, but then that goes completely against EHDS, because then you can purposely design your studies in a way that will exclude EHDS, right? And then this becomes like a paragraph 22. So I think the definition is very broad. We have some guidelines from the European Commission. We all know it's not binding, but it is a starting point. It does touch upon and explain about data holders, but I don't think it's this guidelines is granular enough for the reality. So. Yeah, I am very happy that these discussions take place, and hopefully more and more will come out and there will be more clarity on these issues.
Thanks a lot. I think we can take one more question.
Yeah, maybe just one more.
One, okay.
If you,
one small question. Yeah, I didn't track the hands. Yeah.
Thank you. This is Xiao from EORTC, and we actually discussed this and we could not find answers, so hopefully you can help us. It is the follow-up question on the consent-based repository. So if the repository provide data, I mean, if a sponsor asks data from HDAP, and obviously when the patient originally consented to the data repository, they have no idea this data will be used by the sponsor. My question would be, how could the patient be involved? Be informed, at least, and do they have the right to opt out, and how to opt out?
Yeah, I think it's a good question. Is it a case of free consenting, or is it only providing some information would make it?
Yeah, again, it's kind of a similar question, the first part anyway, from the consent. I think we should make a difference, and I think it's something, and it's good that it's being raised, because I think it's something that should be tackled in the future. I mean, unfortunately, we cannot change all the informed consents that have been signed. I mean, we could do that, but I don't know. I think the only thing at the moment that we can do is try to make sure that it's kind of included in future informed consents, where there's at least a clause or whatever. But there's nothing more we can say. It's a good point. From the opt-out, I think it really depends on how the way opt-out will be organized at the national level. And that's, yeah, even more complex, I would say. That's why I think many countries are still figuring out how to organize opt-out and how to deal with such repositories, and when or not should we take the opt-out into account. So there's still many questions, I think, definitely.
Thanks so much to our panelists and to the audience for listening. I think this was a very productive discussion. It left us also with many questions, which is, I think it's good, because we need the good questions now to think about them before the implementation phase. But I think we discussed so many important issues, from incentives to trust to all these legal uncertainties. But I think it was also reassuring to hear from you that you will also benefit from the experiences and existing experiences from these health data repositories. So thanks so much for all your contributions and for listening to us. I think you are expected for lunch. Thanks.